So a very good evening and good morning one and all present here in this webinar. I thank you all for sparing out your valuable time and being a part of this webinar organized by markpatent.org and sponsored by HK Acharya and Company. This is your host Jalashri Dave for this webinar and a part of markpatent.org. I warmly welcome all of you. We hope you are staying positive and testing negative. With this webinar, we are accessible to a global audience that brings together a wide and varied group of people connecting in this digital world. Namaste. Before I start, I would like to give a quick introduction about our organizer and co-organizers. Organizer, markpatent.org. Markpatent.org, established in 2004, is actively associated and dedicated to the support and advancement of intellectual property elements. The main object of the organization is to provide in-depth understanding and to create awareness of the intellectual property rights among attorneys, advocates, professors, law students, and also among manufacturers, industrialists, and LLM intellectual property rights. Xavier's Research Foundation. The Xavier's Research Foundation Trust runs the Loyola Center for Research and Development, an autonomous institute which was established in the year 1987 in St. Xavier's College, Ahmedabad. Its goal is to do research in science and technology as well as the humanities. The center not only provides scientific staff dedicated to the research, but also provide infrastructure, support, and expertise to the students working on the frontline research field in environmental microbiology and plant biotechnology. The mission of the center is to target grassroots communities on the fringes of our economy and through innovation, entrepreneurship training, and handholding set up production units at medium, small, and micro levels. ICFAI Law School, Hyderabad. The Faculty of Law School, commonly known as ICFAI Law School, is a constituent unit of ICFAI founder for higher education, located in the lush green environment in the vicinity of the historical city of Hyderabad. The ICFAI Law School, with excellent and continuous teaching and learning process, student-centric and industry-friendly dynamic curriculum, and real-life exposure, provides best-in-class legal education to the student and carving them to market-ready legal professionals out of the mediocre student who desire to making law as a career. All the UG programs offered by ICFAI Law School are approved by the Bar Council of India, and other programs are in accordance with the UG norms. USIIC, the United India Importers Council, is not a profit initiative started by a group of Indian SME importers responsible for imports of over $1 billion from USA. It is the only exclusive importers council in the world. USIIC acts as an intermediary organization to facilitate partnership and trade between Indian and American businesses, and thus acting as a catalyst in promoting economic growth between United States and India. Rotary Club of Ahmedabad Elite. The Rotary Club of Ahmedabad Elite is an active club of the Rotary International Organization, having played an important role in various emerging issues and helped to find a serving society. The club is actively working in various sectors, including environment, education, and women's healthcare development. This club has been serving it since 2010 with various prominent personalities from the city. We thank and extend our full support to the Rotary Club of Ahmedabad Elite for this noble cause. And Gujarat Technological University. Gujarat, in the field of engineering, architecture and management, pharmacy and computer technology university, is a premier academic and research institute that has driven new ways of thinking since the 2007 founding, established by Government of Gujarat. Today, Gujarat Technological University is an intellectual destination that draws inspired scholars to its campus, keeping GTU at the nexus of ideas that challenge and change the world. GTU is a state university with 486 affiliated colleges in its folding operating across the state of Gujarat through its 5 zones at Ahmedabad, Gandhinagar, Vallabh Vidyanagar, Rajkot, and Surat. IT is a pioneer in introducing some innovative learning methodology by active learning. So once again, we are thankful to our organizer and co-organizers. So now moving forward, may I please welcome our dignitaries, patent attorney at HK Acharya and Company, Mr. Kunal Dalsania, our honorable chief guest, founder and board member, CEO Autodesk, CEO G Secure Labs Gateway Group, Mr. Indrajit Mitra, inventor, founder, and chairman of Patent Books in INC and TS Corporation USA, Mr. Arthur Nutter, patent attorney BCKIP, Part MBB Germany, ING Sebastian Grading, Intellectual Property Attorney, Fast IP Trademark and Patent Services Private Limited, Dr. Mohammed Asif, and Patent Attorney at HK and Company, Mr. Nitin Patel. I heartily welcome all of you. So now I request Mr. Kunal Dalsania to address our guest. Mr. Kunal Dalsania is a patent attorney at HK and Company. He holds a bachelor degree in pharmacy and law from Gujarat University. He also holds a post-graduation diploma in patent law from National Academy of Law, Studies and Research, Hyderabad. He also possesses a master degree in science and nanotechnology from Gujarat Forensic Science University, Gandhinagar. His practice includes prior art search, drafting of patent application, patent prosecution and opinion work, primarily in the field of pharmaceuticals. He has also given presentation on patent, has various forums in India as well as in abroad. So now I request him to address our guest. Over to you, Mr. Kunal.
Thank you, Jalashri. Am I audible properly?
Yes.
Okay. First of all, good evening, everyone. I hope everyone is doing good in this difficult time and have a sound health in this pandemic situation. I, Kunal Dalsania, welcome you all on behalf of markpatent.org in today's webinar on the topic of software patent protection, particularly related to global scenario. I welcome you all on this webinar, informative webinar. Dr. Acharya, the managing trustee of markpatent.org, has not able to attend the webinar due to unavoidable circumstances, but he has conveyed his greetings to this webinar covering these crucial aspects of software patent. Related to today's, specifically today, in India, we celebrate 26th November as a constitutional day, as a remembrance of adoption of constitution on November 26, 1949. So this is a very special day related to Indian law history also. In the current time, if you are speaking related to software, in the current time, software and computer programs face a cutthroat competition in the market and are pretty vulnerable to suffer undue economic loss, as it might accessible by users without payment, and also others of software are particularly vulnerable related to piracy and being copied. Further, due to fierce competition, there is a serious threat of being outdated very soon, as it's a nature of this industry. So as soon as the competitors might bring a competing product, it is very quick to bring a competitors to a copied product. So protection of the software under IPR mechanism will not just protect the economic interest of the owner, but also it will promote innovation and creativity. Particularly related to patent, the patent becomes essential for the protection of software, as patent works on the scope and not on the how one has developed that work. So patent can be ideal situation when we question the concern related to protection of ideas and functional aspect of software. Regarding India, actually in ancient times, regarding India, it calls as a golden bird. It's the land of the golden bird. But as the technological development in development of patent-related economy and in a growth of GDP. If we quickly look into the patent application filing numbers released by World Intellectual Property Organization (WIPO) specifically for 2020, despite pandemic, there is a growth of 1.5% patent filing in related to global scenario. Related to India, if we are speaking specifically related to Indian perspective, despite this pandemic, the India has reported growth of 6% of filing patent application for 2020 on WIPO. So it's a very crucial market to cover related to this, specifically related to software patents. So on behalf of markpatent.org, I would like to welcome our esteemed speaker who will guide our audience about the software patents scenario in their respective jurisdictions. First, I would like to welcome Mr. Indrajit Mitra, who is the chief guest of our webinar, and he's a visionary personality from the Gateway Group, one of the software designing company from our own city of Ahmedabad, Gujarat. Further, I would like to welcome Mr. Arthur Nutter, who is the founder and chairman of Patent Books Inc. USA, I would welcome Mr. Sebastian Reading, who is a patent attorney from BAC IP, Germany. I would welcome Mr. Mohammed Asif, who is IP attorney from Fast Tech, Pakistan. At last but not least, I welcome our enthusiastic audience on behalf of markpatent.org, who will surely going to have a knowledge and great learning from the galaxy of speakers. I request Jalashri to take further event.
Thank you, Mr. Kunal. Your thought-provoking welcome address set a perfect platform for our speakers to deliver their presentation in the areas of software patent protection with reference to global scenario. So this webinar will have series of sessions which gives flavor to the remarkable diversity of the subject, software patent protection with reference to global scenario. So let's start the interesting session with our very first speaker and our honorable chief guest, Mr. Indrajit Mitra. As a co-founder and technocrat, he stirs the company's strategic direction, development, and growth through sustained technological innovations and set out the product roadmap. As the group chief technology and innovation officer, he guides the team in attaining the company's goal to set out in the annual plan. The framework on which Gateway Group has created is niche and is preferred technology partner for global clients in his doing. He heads a powerful multi-platform and skilled technology team with whom he builds capabilities that achieve quality benchmarks. Indrajit has taken it upon himself to aid the growth of Gateway as an innovative hub. He has consistently delivered a positive change and built a winning team at Gateway. His leadership inspires his team to outline the standard and provide innovative solutions for the next generation technology. Before he joined Gateway, he managed large-scale projects at Veritas Inc. He has over 20 years of experience and has a bachelor degree in science and a master in computer applications from Gujarat University. He has an executive MBA from Haas School of Business, UC Berkeley, California. So now I request him to present his thoughts with us. Over to you, sir.
Thank you. That was quite a long appreciation. I almost read through my biodata. The correction is actually 25 years, not 20. I seem to be getting younger, but nevertheless. So this was a very interesting topic. Coincidentally, Mr. Acharya is our neighbor, and we have not managed to say beyond hi or hello over the last so many years. But pandemic got us all together, and we managed to swap notes, and it was very interesting to see what he had been doing. In India, if you understand subject about copyrights and patents is a little Greek and Latin still, but a lot of innovation happening. So it's a very pertinent topic in terms of patent as a patent. Overall, everybody relates it to some invention, innovation, primarily gotten to do something with something which is tangible or something which is visible in terms of a hardware or so on and so forth, or a device and so on and so forth. So which brings around to a very, very interesting point that at this point of time, everything is what we used to call, even back in Semantic and Veritas days, as software driven networks or algorithms and data and so on and so forth. So everything suddenly turned around its head over the last 2 years and everything went digital. And it has become more important for us to figure out this animal so as the software patent protection piece of it. So from whatever limited understanding I have, even though running a tech industry for so long and having offices across 15 geos in Europe and US and other places also, interestingly, every country behaves in a different way in terms of the interpretation. The software patent per se is a pretty loosely termed subject, and everybody has a different take on it. And according to me, the software so-called patent is not really patent. More and more people are more focused towards the copyright part of it, not the patent part of it. And that's going to be very interesting, and even interesting for me to learn from Mr. Arthur and Sebastian as to how does one circumvent this, especially in a scenario like India, where we talk about copyrights mostly. How does that get converted in patent? Because obviously patent is what is, even the idea gets protected. whereas most of us who are on a regular basis churning out concepts, but are now moving towards productizing everything in a SaaS or a DaaS or a PaaS-based environment, it is very, very important for us to figure out this minor gap from moving from a copyright to a patent and why it is so important. So yeah, I mean, it's something which I look forward to hear from all of you, Dr. Asif as well, as to the experiences and working towards how to get there. Thank you.
Thank you very much, sir. We are honored by your esteemed presence. And thank you once again for gracing this event. So let me introduce you all our next speaker, Mr. Arthur Nutter. Mr. Arthur is the inventor, founder, and chairman of Patent Book Inc. and TS Corporation. He is a strategic perseverant visionary that likes to create and lead. Mr. Nutter is listed by the IP Media Group as one of the intellectual asset management's world leading IP strategies since the publication began in 2009. Mr. Nutter founded TS in 1992 as world's first engineering company dedicated exclusively to managing and monetizing intellectual property. TS was bootstrapped from its humble beginning in Colorado Springs, Colorado, to a global enterprise and now incorporated to the US, UK, Japan, Malaysia, and Colombia. He has been a member of the Licensing Executive Society USA and Canada since 1994, was head of LES High-Tech Industry Sector for 7 years, and also was the head of LEC Communications Committee for 3 years. Mr. Nutter challenges the patent licensing industry from the podium regularly at global events and is widely published. He also holds a BSME from University of Akron, Ohio, an MBA from University of Phoenix, and is certified licensing professional. He is a Catholic and instrument rated pilot, rides Harley Davidson motorcycle, and is certified scuba diver, and also directs music. So now I request him to present his view with us. Over to you, sir.
Sure, thank you. Boy, you don't hear that very often from folks, the whole background bit. But thank you for asking me to provide my opinion on this. We have a very unique perspective here on software patents, and ours is that of a technical perspective. If I take a look at products that contain lots and lots of software, this iPhone, for instance, we have to say, all right, are there patents on the software that's in there? Most of the time, you think about patents in terms of copyright. And copyright's fine. It's super easy to get. It's inexpensive and all that. But there's not a lot of teeth in copyright law. You can say, okay, you've used my copyright. That's fine. But monetary damages and compensation are fairly trivial in copyright land. On the other hand, when you take a look at patents, there's a lot more meat there. There's a lot more money available for patent infringement. However, when you think about software patents are kind of interesting. If we're looking at code, software code, and you're talking about the claim language, and of course, if you're talking about patent infringement, you have to focus on the claim language. The claim language doesn't talk about specific algorithms. Well, it does talk about algorithms, but it doesn't give you specific lines of code that said they have to execute the algorithm. The coding is a function of whatever that coder is, whatever language the coder is writing in. But yet the algorithm has to be present in there. So when you're reverse engineering, and by the way, TAEUS is an acronym for Take Apart Everything Under the Sun. That's what that company does. When you take that software apart, you have to document the algorithm, exactly what it's doing, and see if it actually compares favorably back to the patent itself. That's a challenging exercise because by the time the algorithm gets into a device like this, it's ones and zeros. It's embedded code. So you have to dump the ones and zeros, disassemble that code back into something that resembles source code. And you can do that. Quite often we have to write custom disassemblers to do that. And then then you can get, like I said, something that resembles source code. It's not the actual source code because the source code itself would have comments in it most of the time. And you don't get any of the comments in compiled source code. But then you have to compare that back to the algorithm that's articulated in the claims themselves. And so that's a bit of an involved process. It's not it is expensive, and therein the expense, it really gets to the heart of software patents. We worked on a case involving Motorola. As you guys remember, Motorola was big in cell phones a couple decades ago. And they patented lots and lots of their software algorithms. And they, at the time, thought that Qualcomm might have used some of their software algorithms. And so we looked at these patents. We said, yeah, okay, yeah, we could investigate this. And I went through the process with them. Okay, yeah, we'll have to take the Qualcomm processor, dump the code out of the processor. Again, it's ones and zeros. Then you have to disassemble it, and went through that process that I just described previously. And you might find that they did something a little different. And as long as they did one thing a little different, then there's no patent infringement. Okay, because that's all you have to do is find one thing that's different in there, and you avoid the patent infringement algorithm or argument. And but unfortunately, it's a really expensive process. Okay, to do that kind of analysis on a Qualcomm chip was in the neighborhood of $1 million. And when we presented this information back to Motorola, they said, "Oh gosh, we're not going to do that. That's $1 million. We're not going to spend $1 million to see if Qualcomm did this." I said, "Well, oh, okay. Guess what? You made it easy for them to copy because you put the algorithm in your patent." Okay. Now, if you're not willing to spend the money to do the reverse engineering to document whether or not the other guy, your competitor, has used your algorithm, then you shouldn't have patented it to begin with, because what you did is you made it real easy for the guy to copy. He copied your algorithm, he wrote it in the same code, but you told him how to do it in the context of the patent. So in many cases, we will discourage people from actually patenting the software and maintain it as a trade secret, because if it's so expensive that for a competitor to acquire your product and reverse engineer it to try to duplicate the software code in there, then chances are good they're probably not going to do it. But if you made it easy for them by putting it into a patent, well, then you've kind of let the cat out of the bag. And in that case, Motorola did not proceed with that sort of investigation. We asserted a whole bunch of other patents that Qualcomm was using, Motorola patents that Qualcomm was using against Qualcomm. But we had to do this again and again and again. And we see this quite often as people, you have to look at the degree of difficulty of reverse engineering the software code and make an intelligent business decision as to whether or not it makes sense to actually secure the patent. Getting the patent's nice, but if you don't have the money or the resources to enforce that patent, you're better off just treating it as a trade secret. At least that's my perspective on this. Any questions on that? Because you guys have been dealing with this as well, and I'm happy to talk to you about that. And we were the technical experts when the European Commission investigated the Microsoft Windows operating system as well for antitrust. And one of the things that we discovered there in the process of reverse engineering the Windows operating system was that the instructions that they provided to the industry to write compatible code really had nothing to do with the way the code operated. Okay, it was a complete misleading document, but that allowed Microsoft to stay ahead of everybody because nobody else could write compatible code with it. And the Windows operating system was a dominant operating system throughout the world. And so they enjoyed that, shall we say, monopoly they alleged, oh, well, we didn't know that our instructions didn't work, but they laughed all the way to the bank on that one. So, the 900 or the 9 million euros that the European Commission spent with us to prove that Microsoft was not behaving appropriately, shall we say, yield them a $1.4 billion fine. So the ROI was pretty good for them on that. Anyhow, that's my perspective on that. And again, any questions, I'm happy to talk to them, because we have our hands dirty in software analysis.
Thank you very much, Mr. Nathar, for discussing this topic in a very comprehensive way. And the question answer session will be arranged at the end of the session.
Okay.
So let me introduce you our next speaker, Sebastian Grering. He has completed mechanical engineering, focus in medical engineering and microtechnology, first class honors for diploma thesis in the field of cochlear implants in 2014. From 2014 to 2018, he has been training in renowned patent law firms. In 2018, he took admission at German patent attorney and European trademark and design attorney. Since 2018 to 2021, working in one of Europe's leading patent law firms. He mainly focuses on patent prosecution, opposition and appeal proceedings and litigation in the field of medical engineering, computer implemented inventions, artificial intelligence, mechanics, microelectronics, and automotive engineering, as well as trademark and design. So now I request him to present his views with us. Over to you, sir. Sir, kindly unmute your audio.
No. Okay, good afternoon. So I provided some slides. I will quickly share my screen.
Sir, sorry for interruption. Can you speak a bit loud?
Sorry, can you now hear me?
Yeah.
Yeah, okay, all right. So I provided some slides and I will quickly share my screen. So I will introduce you to patents for computer implemented inventions in Europe. And that's a rather complex topic, and I will try to give you a general overview. And so let's start right away, because it's quite a lot to show you. So I would cover those 4 points. First of all, I would talk about technical inventions. Next thing, patentability. Then we will look at the 2 hurdles for computer implemented inventions in Europe. And finally, I will show you a very, very simple example. Yes, let's begin. So, according to European Patent Convention, patents will be granted for inventions in all fields of technology. That's an undefined term. So technology is not really defined in the European patent law. And that's intentional, because technology will evolve over time. And if we had a strict definition of what technology is, then maybe some new technologies would be barred from patent protection. And of course, that would be not good. But we have some explicit exclusions, so-called non-inventions, which are barred from patent protection, at least in Europe. Those non-inventions are the following. And as you can see, there are also listed programs for computers and presentations of information. All those inventions are barred from patent protection if they are claimed as such. What does as such mean? For example, if you have some computations of some values, and you just claim them as simple computations, then those are barred from patent protection. But if you add a step of controlling or maybe deriving some parameters for a production process, then your non-invention becomes a technical invention, and you may become and you may get a patent granted in Europe. Next thing, patentability. I don't know, the audience is quite broad, and I don't know how deep you are into patents, but three of the main prerequisites invention has to have are novelty, non-obviousness, or how we call it, inventive step, and it must be susceptible of industrial application. Only if those prerequisites are met, then you can get a patent on your invention. So let's have a look at computer implemented inventions in Europe. We have two hurdles which have to be overcome in order to get a patent granted. The first hurdle is the technical invention. As already mentioned, only technical inventions are susceptible for a patent. And the second hurdle, which is rather higher than the first hurdle, is the inventive step. So, if you have a, let's say software, a computer implemented invention, how can you ensure it is recognized as a technical invention by the European Patent Office? Your invention must have an impact on the real or physical world. How can you achieve this? That's rather simple. You just have to ensure that your method is actually implemented on a computer. And we have specific accepted claim wording in Europe. And if you use this specific claim wording, then you should have no problem with the first hurdle of technical invention. Let's look at this claim wording. Here are some of the accepted claim wordings. I know it's rather small, and I'm sorry for this slide, but I thought maybe you could use this later on as some reference. So first of all, you could always claim a method. If your method comprises only non-technical steps like calculations, your inventions are non-invention, as we saw before. But if you simply introduce the words computer implemented before method, alone this little amendment will guarantee that your invention is regarded as a technical invention. Of course, you could also claim a apparatus, a device, or a system comprising means for carrying out some method. This is, of course, a technical invention, and you should have no problem with this one. And as you can see in the next point, you could also claim a computer program. I told you before, computer programs are excluded from patentability, but if you claim a computer program and if you add this little clause when the program is executed by a computer, cause the computer to carry out the method of claim 1 or the steps A, B, C, D, then this claim or the subject matter of the claim is regarded as a technical invention. And of course, you could always claim a storage medium or a data carrier on which this computer program is stored. The bigger hurdle to take will most certainly be the inventive step. As we saw before, inventions or let's say features of your claim that fall under the non-inventions, for example, mental acts or display of information, they will not be regarded in the discussion of inventive steps by the European Patent Office. So in Europe, we have developed the so-called COMBIC approach, and this approach comprises three steps. And by means of these three steps, the European Patent Office will establish whether your invention fulfills the requirement of inventive steps. Let's have a look at the COMBIC approach. So the complete approach, as I already told you, has 3 steps. In the first step, subject matter of your claim is analyzed and it is separated in technical features and non-technical features. Technical features are all the features that have an impact on the real physical world. All the other features are regarded as non-technical features. For example, any calculation step, because a calculation is a mere mental act. A normal human person could maybe do it. Maybe it would take a long, long time to do it, but a human could do it, and so it's a non-technical feature. In the next step, the non-technical features are analyzed. If the non-technical features contribute to a technical effect, then they will be also considered during the assessment of inventive steps. For example, if you have a claim 1 and it comprises 2 calculation steps and a step of controlling the machine based on the result of the calculation step, then the last step, the control step, is of course a technical feature because it has an impact on the real physical world, in this case, the machine. The first 2 features, the calculations, are non-technical features because they are just mental acts. However, those 2 technical features contribute to the technical effect because the result of those 2 non-technical features is used in controlling the machine. So in the final step, step C, when we discuss the inventive step, not only the last step, the control, but also the 2 calculation steps will be considered by the European Patent Office. And that is, of course, very important. So you should always try to ensure that all your non-technical features, in particular, every calculation and every result of every calculation is somehow connected to a really technical feature like a control step or a manufacturing step. So yeah, I summarized this here. Non-technical features like calculations, which are regarded as mental acts, or displaying values, display of information, do provide for a technical effect in case the result is used in or for a technical step. And I have prepared a small example to make this a little bit more understandable. So let's consider we have this method claim, a method X, Y, Z comprising the steps doing a calculation A and doing a calculation B. If the European Patent Office would examine this claim, they would raise an objection because the subject matter of this claim is a non-invention. Why? That's only a mere mental act, non-technical features, and there is nothing more than non-technical features, so we have a non-invention. What could we do? This is by way the first hurdle. We have to make the invention a technical invention. We simply add computer implemented method for X, Y, Z, comprising the steps doing calculation A, doing calculation B. By this simple amendment, we ensure that the subject matter of our claim is regarded as a technical invention. However, we now have a technical invention because the method is executed by a computer, all right, but still, steps A and B are non-technical. And for the second hurdle, the assessment of inventive steps, they would be disregarded. So if we cancel the last, the 2 features, calculation A and calculation B, all we have is a computer implemented method for X, Y, Z. And that's, of course, very obvious. Any method could be implemented on a normal computer, and that's nothing very inventive. So of course, This subject matter of the amended claim 1 would still there would still not be granted a patent because there's no inventive step included. So how can we ensure that our two features, the calculation A and the calculation B, are considered for the assessment of inventive step? We amend claim 1 again, and we add a third step, causing interaction C with a physical entity, for example, controlling a machine or using the results of the calculations A and B in a manufacturing process. If we do that, then for the assessment of the inventive step, not only the step C, which of course is a technical step, but also the steps A and B are considered because the steps A and B provide for a technical effect via the step C. All right. Thank you very much. I hope, yeah, this fast and very general overview of what you have to do to make your software patentable in Europe has brought you something. You should simply remember, first of all, you have to ensure that your software is regarded as a technical invention. You can simply do this by adding this computer implemented statement before in front of your method claim, or by using the claims. I've shown you some slides before. And the next thing you should always bear in mind, you have to ensure that your non-technical features, most probably calculations, if you are talking about software, then your calculations must have an interaction with a physical entity in a controlling step, in a manufacturing step, or whatever. All right, thank you very much. In case you should have any further questions, I have added a little QR code. This will lead you to my LinkedIn profile. So maybe if you need some assistance in prosecution in Europe, just write me via LinkedIn, or of course you could contact me via email. And then, yeah, let's see if we can get your software patented in Europe.
Thank you very much, Mr. Sebastian, for exceptional presentation. So let's move forward to our next speaker, Dr. Mohammed Asif. Dr. Mohammed Asif is an experienced intellectual property attorney at Fast IP Trademark and Patent Services Private Limited. He has over a decade of experience in the patent and intellectual property field. He worked as a patent examiner for the Intellectual Property Organization of Pakistan, as well as for some of the leading firms in this field representing healthcare and technology clients in Pakistan and MEA countries. Dr. Asif has obtained several advanced training related to the IPR and patent examination from Japan Patent Office at Tokyo, Japan. He has also won several awards in technology transfer pitching competitions organized by international organizations. So now I request him to present his views with us. Over to you, sir.
Thank you. Are you listening?
Sir, your voice is quite slow.
Is now appropriate?
Okay, perfect.
Okay, I want to share my slides presentation with you. First of all, I'm very thankful to Patent Marks organization and the other colleagues present here. Greetings from my side, and I have learned from the other colleagues their views about the copyright. And I think the most of the countries have a same scenario with respect to the software patent protection, as widely I have comparatively seen in different countries that mostly the software patents are computer implemented inventions in a direct way are not allowed. The same scenario almost is in Pakistan, and other subcontinent and Middle East countries. I will give you some legal provisions of the patents which hinders the software patents in Pakistan in this slide. Before software patents provisions that restrict the patent protection in Pakistan, I would like to give some patent laws that governs the patent protection, which are the Patent Ordinance 2000, patents in amendment being made in the ordinance in 2002, and the patent rules 2003. As we all know that after the post TRIPS era, these all regulations being made. Otherwise, before there was a patent law of 1911, which was a single law that been one for the patent protection in all over the subcontinent region. And the similar was implemented in Pakistan, but after the TRIPS agreement, these all changes being made. And Pakistan is also a member of international treaties and conventions such as WTO TRIPS agreement, Paris Convention, and other WIPO convention related conventions. In the patent law of Pakistan, the term invention, process, and product are defined as that invention means any new and useful product or process in any field of technology and includes any new and useful improvement of either of them. So this is basically the definition that provides area that in any field of technology. So any which includes as well the IT industry, software. So mostly when the patent office subject on the applications that are related to the software. So mostly people argue on that basis that the patent law allows that if the invention is related in any field of technology, then if the other provisions are hindering, then this provision of invention definition is allowing because it says in any field of technology. It is not restricting the computer implemented inventions. The process term is defined as any art, process, or method or manner of new manufacture or product, and the term product is defined as any substance, article, apparatus, or machine. Patentability criteria is same as all over the world, that is a novelty, inventive step, industrial applicability, and the nature of subject matter, which means any exclusion from the patentability. If some subject matters are excluded, these are definitely considered in the patentability and are refused on the basis if the product or process is not falls in the patentability criteria. Novelty requirement is absolute or worldwide in Pakistan. It means it should not be disclosed before the priority date of the application in anywhere of the world, and this is a novelty basically rule. Before of the 2002 law, there was a local novelty rule, and after the TRIPS agreement, this definition will change from local to worldwide. The inventive step provision basically says that it should not be obvious to any person skilled in the art. This is the second main criteria of invention that must have to be fulfilled. Now towards the subject matters which are excluded, basically the section 7.2 and the subsections A to E of the patent law states that the following matters shall not be regarded as an invention. That is A, a discovery, scientific theory or mathematical methods. B, a literary, dramatic, musical or artistic work. C says a scheme, rule or method by performing mental act. The B, the presentation of information, and E, substances that exist in nature or if isolated therefrom. The main provision is section 2A, which says the mathematical methods are not considered as an invention. That is a whole hindrance of the software patent in Pakistan, as usually in other part of the world. In view of section 72.7.2a, the computer programs do not fall within the statutory list of non-patentable subject matter, therefore are not patentable as such. So this is the same as almost is comparatively to the US practices. The computer program per se patents are not allowable. The term computer program is although not used in the patent law, but it is envisaged as similar to the mathematical method, which is specifically excluded from the patentability. However, the inventions involving the use of computer programs, that is computer implemented inventions, can be protected provided that the invention computer program products resulted in additional technical effects that went beyond the normal physical interaction between the program software and computer hardware on which it operates. So this is the main way to protect the computer related inventions, that a computer program per se inventions are not used, are not allowed by the patent office, but if the computer implemented invention or the software has some physical interaction with the software related devices, then it may be patented or may be allowed by the patent office. In view of the aforementioned provision and general interpretation followed by the practice of the patent office, a claim for a computer program per se is not allowable. So it is a wide, long-standing practice of the patent office that a computer program or software program per se claim, specifically if we use in the preamble of the claim, then it is straight away rejected by the patent office. But in order to make it allowable, and if the invention, the computer program is linked with the physical device and have technical effect, then the practice is to claim in terms of a system or device or method. Means for the effectiveness of the system or device or method for operating and operators may be allowed if meet all other criteria of patentability. So if the invention is have a physical ingredient, physical hardware ingredient in the invention along with the software, and be claimed by the in terms of system or device or method, then this is the only a way to get the patent of the computer programs or software in Pakistan. Conclusion, computer program software may be protected in the Pakistan if it is novel, inventive, and tied to a device or a system comprising hardware features having additional technical effects. And I would like to add here the practice is that in the recent years, several applications around 20 to 25% will increase in Pakistan with the Android system and the other operating system of the mobiles, and a lot of applications related to the mobile apps are being filed by the locals and as well as for the other countries in Pakistan. So by this system, people are a lot of inventors and these software-based houses are applying through this protocol, and getting the patents as well, and patent office allow the patents on the basis of the claim in terms of system, device, or method. So this is all about from our side, and this is, if you have any question regarding this, you may please ask. And over to you.
Thank you very much, Dr. Asif, for this informative presentation. So now I request Mr. Nitin Patel to address this gathering with his vote of thanks. Mr. Nitin is a patent attorney and works with the patent division of HK Acharya & Company. He holds a bachelor degree in electronics and communication from Hemchandra Acharya, North Gujarat University. His principal focus is around patent identified with electronics and communication. He is engaged with prior art search, drafting the patent application, and replying the office activities. So now I request him to deliver a vote of thanks. Over to you, Mr. Nitin. Kindly unmute your audio.
Good evening, everyone. As we have come to the end of this webinar, I wish to thank all those who have contributed for successful conduct of this webinar. First of all, I would like to thank the Managing Trustee of markpatent.org, Dr. Rajesh Kumar Acharya, for arranging this wonderful webinar. welcoming the participants, Mr. Kunal Darsania stressed on the growing importance of protecting software piracy and how patents help protection of software. Our chief guest, Mr. Indrajit Mitra, laid emphasis on spreading awareness about the need to convert copyright of software into the patents. I would like to extend my gratitude towards Mr. Arthur Nutter. Mr. Nutter explained that simplicity features and economical cost of registration of copyrights and inventors' desire to maintain trade secrets is what drives the preference of copyrights over the patents. He also informed that compensation by way of copyright is trivial as compared to the patents, and so registering software as a patent will pay richer dividends and would be much more profitable. Speaking on patents for computer implemented invention in Europe, Mr. Sebastian Grading from Germany gives details about the patentability of such invention in Europe and the hurdle faced thereof. He also outlined the impact of the technical inventions and the constituents element of non-technical features. Dr. Mohammed Asif from Pakistan spoke about the patent laws in Pakistan with special preference of softwares. He also talked about the various changes brought about after the TIPS agreement. I would like to thank the sponsor of the webinar, HK Acharya Company, and the co-organizers, Institute of Law, Nirma University, School of Law, Gujarat University, Loyola Center of Research and Development attached to the Xavier's Research Foundation, ICFA's Law School Hyderabad, USIAC, that is United States India Importers Council, Rotary Club of Ahmedabad, Kerala, and Gujarat Technological University for their continued and unflinching support to mark patterns in propagating the awareness of intellectual property rights. Last but not the least, I would heartily thank the participant for showing active interest in our webinar and encouraging us to keep moving forward. Thank you, everyone.
Thank you very much, Mr. Nitin. In closing, I wish to express my gratitude to all the panelists, delegates, and observers for their full cooperation and active participation. I would like to thank you all to all the wonderful people who spoke and enlightened us with their amazing knowledge and ideas. It's been an honor to be among such an accomplished individuals. Thank you all for your patience. We are privileged to have in attendees such distinguished experts as well as observers, having such resourceful and knowledgeable delegates who have helped us to gain insight on a strengthening mechanism as a means of promoting IPR. We convey our sincere appreciation to our distinguished guests who has been actively participating from all way across the globe to make this webinar a huge success. I wish Mr. Arthur have a blessed and a good day. Mr. Sebastian have a good afternoon, and Dr. Asif and Mr. Indrajit have a good evening. So with this, we sum up our session. Thank you, ladies and gentlemen. Wish everyone to stay home and stay safe.
Okay, thank you.
Thank you very much.